Right from the jump, the judge is setting the tone. This isn't a small-time resisting arrest case. This is a 15-year felony, which already tells us someone got seriously hurt. Pay attention to how quickly this goes from routine stop to major legal consequences.
Serious injury, 15-year felony, guidelines range of 43 to 86 months, and maintaining high court misdemeanor, maximum 2 years, no guidelines.
Here's something interesting. The prosecutor is arguing that 2 officers should count as victims for sentencing points. Why does that matter? Because more victims equals higher guideline score equals potentially more prison time. Do you think both officers should count? Let me know.
There are no charges. I believe that's probably scored at 10 points.
As Officer Meyerson is trying to get the defendant out of the vehicle when he refused to exit, he's physically resisting and grabbing her hand and wrist, causing the injury during that struggle. And then when she felt the pain in her hand and told the defendant to let go of her hand, says then Officer Gomez then took over trying to get the defendant out of his vehicle. So it was a continuous event occurring as officers are trying to physically extract the defendant from his vehicle because he's refused to do so. And one of the 2 officers was seriously injured. I think it's certainly reasonable, and by a preponderance, the evidence would find that both of the officers were placed in danger.
Not less than 43 months or not more than 20 years. I believe this is a 15-year maximum felony.
Oh, that's correct. That's correct. That would just be a typo.
Correct.
So
he comes before the court at 26 years of age. He does have 5 prior felonies, 5 misdemeanors now at this point. As the report indicates, he was convicted of an aggravated assault while in the jail while this case was pending. It would be part of our argument that the statute allows for a discretionary consecutive as in regards to that case. We would ask that the court not make this sentence consecutive to that one because that is not new felony behavior while on bond or while this case is pending trial. He had not been convicted of this yet when he was sentenced on that case at a district court. And so we would argue that he should receive credit for this 226 days in full. Important note here, I think, is this TBI that his grandfather references as a result of a physical attack from David's father when he was, only 13 months old. Dave's pretty lucky he didn't die from that, and has cost him some irreparable injury to his brain. Even if he were not to have that TBI, I mean, it would still be my position that he's only 26 years old. His brain is just now becoming fully formed. Other than his criminal history would be HIDA eligible. Not that the prosecutor would agree to it in this case, certainly, but I think it's something the court should consider as far as the brain science.
This is where the defense shifts gears, not denying what happened, but painting a picture of a life shaped by trauma, brain injury, and instability from childhood. It doesn't excuse the crime, but it attempts to explain the why. Judges hear these stories often, but the details here are unusually intense.
This all happens really fast. The officers approach the vehicle, they order him out. He's got a lot of questions about, what's your probable cause to do this? Can I keep recording, et cetera, et cetera. You sort of see the writing on the wall before it happens. And as they're putting him on the ground, you can hear Officer Meyerson say, "Stop grabbing my hand like that." And then she kind of, she makes a noise that I would assume is when her hand was actually hurt. I can't say that definitively, but that's what I'm inferring by the video. Officer Gomez then at that point takes over. Mr. Chamas still has questions about why he's being arrested. I don't think those are ever really answered for him, but nonetheless, he's here accepting responsibility for what he did due to his childhood, due to the fact that he was abused by one of the 2 people in his life that were supposed to care for him, and abused so gravely that he could have died. When he is encountered with authority figures who he perceives as being abusive, right or wrong, but as he perceives being abusive, he then reacts to that in what I would say is an inappropriate way. And so I would suggest to the court that in order to counter this kind of behavior going forward, of course, the court needs to consider appropriate punishment for this action, right? But he is still such a young man. that he is going to enter the community again at some point. And I think the court would be potentially misguided in not at least ordering him to do some sort of CBT or cognitive therapy to try to address what's going on with him.
Mr. Shamas, you don't have to say anything today, but you're allowed to. Is there anything you want to tell me?
This is where the defense shifts gears, not denying what happened, but painting a picture of a life shaped by trauma, brain injury, and instability from childhood. It doesn't excuse the crime, but it attempts to explain the why. Judges hear these stories often, but the details here are unusually intense.
And not to try to garner sympathy, but we talked, and when she told me that her wrist hurt, I broke down crying because I was never a violent person, especially to women, because obviously I grew up with a single mom, and that's just not something I've ever had happen before or wanted, and I just can't believe it happened, because it's bad enough that I relapsed at all because I was doing a lot better. I really wished I wish I would have just gone along, even though I really didn't understand what was happening, and I still don't fully understand like all the details of my arrest, probably, I guess, because I was under the influence, fair enough. But it was entirely my fault. I mean, I wish I would have just gone along. I didn't grab her to hurt her. I just didn't understand why she was grabbing me, which I was saying at the time and stuff, but either way, it was my mistake made, and I'm deeply sorry, and I really regret all of this. And I think that's all I can say.
All right, thank you, sir. Ms. Goodrich, people's position?
Yes, Your Honor, if the court would allow Officer Myerson to make a different statement.
Yes, of course. Officer Myerson.
I would like to thank the court and Your Honor for the opportunity to speak today. As a law enforcement professional, I have an obligation to serve and to protect and to be heightened to the needs of the citizens in my community. For the past 20 years, I have faced each situation with the same professionalism and commitment to adhere to the law in the name of safety for others, safety for my fellow officers, and safety for myself. With great pride, I put on my uniform, I put on my vest and my gun each day. One minor misstep might be the difference between peaceful interaction or injury, and in the most egregious situations, even death. I treat this commitment with the same determined focus and with great respect. There's no room to second guess or be deterred. My interaction with you in April of this year, Mr. Shamas, was no different. That is, until you decided you were above the law. You defied my request to cease emptying the contents of multiple cups onto the parkway. You defied my request to answer questions. You defied my request to exit the vehicle. And ultimately, rather than comply with my request, you chose to physically resist and fight me.
Victim impact statements often hit harder than any legal argument. Listen to how many times she repeats, "That choice you made to fight me." It's a powerful rhetorical tool emphasizing consequences. Question for you all: should emotional impact statements sway sentencing this much?
That choice you made to fight me left me out of work for 4.5 months with the possibility of never returning. That choice you made to fight me cost me several thousands of dollars of lost wages. Sorry, Your Honor.
It's fine, take your time.
That choice you made to fight me left my department and the citizens of my community short an officer during the summer months, the busiest time for our township. That choice you made to fight me resulted in our officers being stretched to cover my absence and cost my department thousands of dollars. That choice you made to fight me is the one and only time I've sustained an injury doing the work I love and I'm driven to do. That choice you made to fight me has left me with chronic pain, at times so severe it wakes me in the middle of the night. The choice you made to fight me has left me second guessing my future ability to defend myself from life's abuse. However, I will not be deterred. My commitment to the work that I do is in the name of sparing my community from likes of individuals such as you. While I forgive you for the mistakes you have made, it does not absolve you, Mr. Shamus, from responsibility and the consequences of those actions or the choices you made that night. My statement in front of the court today is to remind you of just that. Thank you very much, Your Honor.
Thank you, officer. Ms. Goodrich, any recommendations?
Yes, Your Honor, thank you. This incident arose on April 14th of 2025. Defendant was found to have methamphetamine, cocaine, and open alcohol in his vehicle. He engaged with the struggle with Officer Meyerson, as she stated, causing the serious injuries that she explained. The defendant is 26 years old. At 26 years old, he has 5 felonies and 5 misdemeanors. He was 14 years old at the time of his first arrest. After the arrest on this incident, and while incarcerated, he was charged with aggravated assault and also pled to an assault, 2 subsequent charges that were violent in nature. He's already been offered services through 2 times juvenile probation, 3 times adult probation, 4 times he's been incarcerated in a county jail, and 1 time he served prison for 30 months. Defendant has been to an inpatient treatment program and also 3 outpatient counseling programs, with the last one completed as recently as February of 2024. Defendant was paroled out of prison recently on November 29th of 2022. Defendant had left his mother's home because he didn't want to obey the house rules there. He was fortunate to have grandparents that were willing to take him in, and he was even in his grandfather's vehicle at the time of this incident. He chose not to use services that the courts have previously offered him or the support his family has previously offered him. He's unemployed with a 9th grade education. The guidelines are 43 months to 86 months. The recommendation is at the low end of guidelines at 43 months. Due to his violent activity while incarcerated in a jail, while sober, while in a secured environment, it leaves me very concerned for public safety and having him in our community. I would ask the court to consider mid to high guideline range in this case. And as part of the plea agreement, there was a restitution amount that was agreed upon for $6,761.80. Thank you.
Thank you, Ms. Goodrich. Mr. Shamas, if you'd please stand for the court sentence. Well, Mr. Shamas, there's some financial assessments that are the easy part here. There's the restitution of $6,761.80 as agreed in the plea agreement. There's state minimum costs of $136, a crime victims assessment of $130, and the court will assess court costs in the amount of $350. The guidelines are 43 to 86 months. You know, I hope you were listening carefully during Officer Meyerson's statement. I mean, all the things that your lawyer expressed about your life are, you know, true things. And all the things that Officer Meyerson explained are true things. And you know, everybody gets the cards they're dealt in life and through their childhood. And plenty of people who've experienced childhood traumas don't have 5 felonies. So, you know, what happened to you may contribute to some of the things you do, but they don't excuse them. There's a path for you to be a law-abiding person. And, you know, I'm sure if Officer Meyerson were to tell us the story of her life, there's things that she's probably had to overcome. Every single human being you meet has had to overcome something. And she's given her life to a lifetime of service to the community. And, you know, as a reward for that, you know, she suffered this injury. Every officer that goes out every shift knows that something like that or worse could happen to them. And they do it anyway. And maybe reflect on, why do they do that? Why would they do that? And see what answers you can come up with. And if the answers you can come up with are just to hassle people like me, I'd say think some more. I don't think that low end of the guidelines is a sufficient sentence given your history and given how you've behaved yourself in the jail. Plus, you have a prior conviction for fleeing and eluding the police. But I also have to consider, I don't think this is an upper end of the guidelines case either.
Here it is, the judge threading the needle. Not the lowest sentence, not the highest. The judge explicitly weighs the defendant's past, the injury, the lack of intent, the jail behavior, and Michigan's sentencing guidelines. This is classic judicial balancing: punishment, protection, and possibility of rehabilitation.
Leave some room that this is not, you know, among the worst that your behavior could have been. So on the whole, I think taking into account your prior felony history, your prior history of felonies involving police conduct, and your prior prison sentence of 30 months that you got out of Emmett County before, and your post-arrest assaults in the jail, I think a sentence at the midpoint of the guidelines is appropriate. So, Mr. Shamas, I'm going to commit you to the Michigan Department of Corrections for a term of not less than 65 months, nor more than 15 years on count on the R&O injury, with credit for 200 days previously served. I forget the case name, Mr. Nightingale, but I think I'm legally not allowed to give him credit for the time he's serving another sentence. And then on the maintaining a drug vehicle, I'll commit you for 16 months to 2 years with credit for 200 days and run those concurrent. I don't think there's reasons on this record to impose discretionary consecutive sentencing. So, Mr. Shamas, that is the sentence of the court. If you wish to appeal, you can file an application for leave to appeal. If you wanted a lawyer appointed for you, I would do so, but you'd have to make that request within 6 months of today's date. We're going to hand you a couple pieces of paper about that appeal process and your rights. One of them we're going to ask you to initial right now, so we have a record that we gave it to you. The other one's for you to fill out if you want to take an appeal. Do you have any questions for me, Mr. Shamas?
No, but thank you.
Okay, good luck. I can't order you to do CBT in the prison, but there's programming going to be available to you in there. So I'd encourage you to take advantage of it.